Welcome to the annual J. Byron McCormick Lecture on Law and Public Policy. J. Byron McCormick served the University of Arizona and the state in three capacities: as president of the university, as dean of the College of Law, and as special advisor to the Arizona Board of Regents. The society was formed over 40 years ago by McCormick's former students, colleagues, and friends as a tribute to him and as a great gift to our intellectual community. We're grateful to the members of the society whose generous contributions make this much-loved lecture series possible. If you wish to join the society, please visit the College of Law's website at law.arizona.edu for information about how to become a member. Tonight, we are delighted to welcome Dahlia Lithwick, one of America's foremost legal commentators. Ms. Lithwick is a senior editor at Slate, writing their Supreme Court dispatches and jurisprudence columns for more than 20 years. She is also the host of Amicus, Slate's award-winning podcast about the law and the Supreme Court. In addition to her work at Slate, Ms. Lithwick's writing has appeared in the New York Times, Harper's, the New Yorker, Washington Post, the New Republic, just to name a few. If you want to hear from her, not a list of where she's published. But I do want to talk about some of her other work. Her 2022 book, Lady Justice, Women, the Law, and the Battle to Save America, is an account of some of the extraordinary women lawyers who worked on behalf of democracy and fought racism, sexism, and xenophobia during Donald Trump's presidency. This became a New York Times bestseller. She's co-author of 2 other books, and her writing has been featured in numerous anthologies. Ms. Lithwick has also made a profound impact as a commentator and a teacher. She testified before Congress about access to justice in the era of the Roberts Court and how Me Too impacts federal judicial law clerks. She's appeared on CNN, ABC, Colbert Report, Daily Show, and is a frequent guest on the Rachel Maddow Show. Additionally, she has held visiting faculty positions at the University of Georgia Law School, the University of Virginia Law School, and the Hebrew University Law School in Jerusalem. Perhaps someday we can get her to add the University of Arizona to that list. In 2018, Ms. Lithwick was honored with the Hillman Prize for Opinion and Analysis, and later that year, she was inducted into the American Academy of Arts and Sciences. We are honored by her presence with us today. Tonight's conversation is entitled The Supreme Court, What's Next? This conversation will explore the impacts of recent United States Supreme Court decisions and what we might expect from the court in the future. Joining Dahlia tonight are University of Arizona law professors Eunice Lee and Tony Massaro, who need no further introduction. The discussion will run for approximately 50 minutes, followed by questions from the audience, if time permits. With that, thrilled to welcome Dahlia Lithwick for tonight's McCormick Lecture, The Supreme Court.
I want to give a shout out to just how fabulous it is to work with her. She is responsive, kind, humble for no apparent reason, since she's so wonderful. And it's been an absolute delight. And I just want to tell the world, thank you for that piece of this, less visible to the crowd, part of your presentation tonight. So what we want to talk about in the limited time that we have, and I'll start, and then Eunice will pick up on the second half. And again, if time permits, we'll have some audience questions. Everybody knows the last 2 terms before the United States Supreme Court have been hugely eventful, and I think impactful. I'd be interested, and I know everyone would, post RBG, what would you identify as the most important overarching themes from those terms? And if you want to drill into a couple of specific doctrinal areas that you think above the fold mattered more, we'd love to hear about it. And I'll turn that over to you and see what you want to say about that.
So thank you, Tony, and really also thank you to Dean Miller for that ridiculously generous introduction. Even my mom doesn't give introductions like that. So it's really such an honor to be here for the McCormick lecture. And, I think I would just start by answering that question in saying this is the most fraught, freighted, complicated time at the Supreme Court that I've ever seen in my lifetime. This is my 25th term covering the court. And nobody's really seen anything like what we are going through right now. And so there's a couple of, as you say, big sweeping things. One is what it means to go from a 5-4 court to a 6-3 supermajority. And what we're learning very, very quickly is that for all the prior years, again, even before I was covering the court, when Justice Powell was the swing justice, then Justice O'Connor was the swing justice, then Justice Kennedy was the swing justice, and for a brief time, Chief Justice John Roberts was the swing justice. And then when Ruth Bader Ginsburg left and Amy Coney Barrett tapped in, suddenly you didn't need to get to 5 anymore because there were 6. And so what we really saw was what my friend Leah Littman at Michigan, Professor Leah Littman, calls the hashtag YOLO court. You only live once. And you really saw a kind of an accelerated, we're going to get it all done and we're going to get it done now and we're going to get it done fast. And so the term, not this last term, but the term before was like nothing any of us had ever seen before, whether you want to talk about Dobbs, which everybody wants to talk about, but equally consequential, Bruin, the gun case that massively expanded the gun rights after Heller, the EPA case where, under this major questions doctrine, which we can talk about, the court was suddenly constraining the authority of an agency to construe its own regulations, and a couple of very consequential church state cases that we can talk about, including Coach Kennedy, the praying football coach case. And all that happened in the most maximalist fashion. So it wasn't just that these were really a raft of 5-4, 6-3 decisions, but there was a way to do Dobbs, and it's the way the Chief Justice wanted to do it, that was minimalist. We're just going to uphold Mississippi's 15-week abortion ban. We're going to move that viability line, and we'll get to overturning Roe another day. Chief Justice Roberts got 0 votes for that proposition because there were 5 people to his right that wanted to overturn Roe. And so I think that last term was a little bit of a pullback from some of that. One of the big themes of the 2022 term was A, tapping the brakes on the maximalism, and B, we saw Chief Justice Roberts regain control of his court. In other words, where he was either dissenting with the liberals the year before or was just a kind of trivial 6th vote, suddenly last term, in case after case after case, he built a consensus around something that looked like moderation. We can talk about whether it was moderation, and managed to pull off either Justice Brett Kavanaugh, Justice Amy Coney Barrett, or the liberals to get himself back in the driver's seat. And very interesting questions about why that happened. In other words, it was Clarence Thomas's court a year ago. It's Chief Justice Roberts' court again now. Maybe the other big broad theme I want to talk about is judicial, what I can only call judicial arrogance. That this is a term, the last 2 terms, but particularly this term, where both on the docket and off the docket, we had the judiciary saying, we are the deciders and we decide everything. When folks were surprised about the outcome in Moore versus Harper, that's the independent state legislature case, and we can drill down on that if there's time. Why did that come out the way it did? Because it was a judicial statement of judicial supremacy. The judges get to decide election law. Time and time again, we saw the court kind of arrogating unto itself the power to make big decisions. And off the docket, we saw it both in terms of the sort of flagrant ethics violations and the court's refusal to do anything about it, But also, I think in the single most consequential move of last year, the Chief Justice was asked to come before Congress and testify about ethics rules, and he just didn't show up. And for the Chief Justice to be asked to talk about something that is roiling the nation, roiling the court, and to take the position that we just don't have to do that, followed by Justice Alito's position that absolutely nobody can regulate us. Congress has no role in telling the court what to do. And so I think in the aggregate, what we are seeing, whether you agree doctrinally or not with what's happening at the court has moved into a posture of we decide all things, we reverse precedent because we reverse precedent and stare decisis no longer binds us. We're going to take big, big swings, and we're not answerable for it to anyone. That's a really remarkable posture for the court to take. And I would just end by saying that's a remarkable posture for the court to take at a moment when it has the lowest approval ratings in the history of polling.
That's such a powerful summary, and touches on so many things that are bedeviling. I think that, and I wonder what you think about this. In some areas, at least, it was hiding in plain view. Take the religion cases. That had been much more chip away, avulsion. And yet, even though I had been watching that particular development for decades and warning, well, here it's coming, and of course told your hair is on fire, stop being hysterical, blah, 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 something you write about in your book that we often hear. I still was surprised by the way in which the court went about defending their results and relying so significantly on dissents and other things of that sort. So those were cases in which I think they were masquerading as incrementalist, but ended up being more avulsions than people accepted. I'm wondering if you agree with that. And it may be, and if I'm wrong, then is it more accurate to say that some cases where you only live once, and the rest were people weren't paying close enough attention to this steady march to the conclusions that Justice Roberts was all in on, and we just had a closer view of what the endpoint would look like. In other words, Dobbs overtook the narrative, and maybe Bruen.
I think that's such a smart and subtle point. I think that one of the problems we have, both as a Supreme Court press corps, and I know we're going to talk a little bit about how we cover the court, but also as a nation, is we are really bad at looking at all of the 72 cases on the merits docket. And by the way, there used to be 120 cases on the merits docket. We are now seeing the smallest number of cases in decades that make it to the docket, but we weight them all as though they have different weights. We decide, right? And this is next week is the week for the magical curtain raiser pieces, where we say these are the 3 important cases. Yeah. And everything else gets downgraded to the point of almost irrelevance. And then at the flip end, when June comes, we disregard all the outcomes except for, the affirmative action cases and the debt relief cases. There were a lot of really important cases on the docket last term, some of them existentially important, not that those 2 were not, but I think we just have a very lazy, habituated mode of covering the court where we get told in October, look out for these 3 big ones, and the rest go away. And so you're quite right. One of the things that the Chief Justice has done so deftly over his career, and I want to be really clear, he is a 3-dimensional chess master. He knows exactly how to do a big thing and make it look small, right? We saw that in the run-up to Citizens United. We saw that in the run-up to Shelby County, where he does something in a case that looks quite inconsequential and then says, oh, well, we already did it. So now we're going to do it in Citizens United. Now we're going to do it in Shelby. And he is very, very, very deft at making it look as though the thing that you and I know happened didn't really happen. That's his superpower. And that's why, by the way, when Justice Alito writes the words, Roe was always wrong. It was wrong then and it's wrong now. It rankles because it doesn't need to be done that way. And the Chief Justice is a real master of optics and appearances. On the religious cases, I want to make one other point. A lot of the shift in religion doctrine has happened on the shadow docket. And for folks who don't know what that means, it's a somewhat nefarious sounding term, and Justice Alito is very prickly about the use of the word shadow docket. It's essentially just the court's emergency docket, which has existed from the jump. We need an emergency docket for death penalty cases and other exigent circumstances. The Rosenbergs happened on the shadow docket. So it's not unheard of for the court to make big decisions in unsigned, quick per curiam orders that come out in the late at night. But here's the difference, and it's important. And if folks haven't read Steve Vladek's, Professor Steve Vladek from UT Austin has an amazing new book out about the shadow docket. If folks haven't read it, it's really a good read, because he makes the point, and I think this is undergirding your point, Tony, that the court decides, it's a discretionary docket. The court decides which cases it will take. And the court is very, very, very clever in docketing cases it doesn't need to take, in not taking cases it does need to take. And if you are in essence in control of the chessboard so that you can say, this is what's on the docket, you're in control of the game. And I think the public perception is that there's some rule whereby the court takes X number of cases because they're essential. That's not right. The court takes the cases it wants to take. And in addition, and this is Professor Vladek's book, the things that it is now resolving on the shadow docket late at night, without arguments, without briefing, often without a real opinion, become law too. And if folks can remember back, even before Dobbs happened on the merits docket in June of 2022, we had SB 8, which was the Texas, abortion vigilante law, which the court blessed the night before the term started on its shadow docket. The court said in a brief, unsigned opinion that was very hard to parse, we didn't know even who wrote it or who signed it, that it was fine for 1/10 of the population of the United States, the entire population of Texas, to lose its access to abortion because of a law that was flagrantly unconstitutional. In some sense, that presaged what came about in Dobbs. But the thing that I want to say about the religion cases is that the court has fundamentally changed the First Amendment religion clauses, and often did it on the shadow docket during COVID with emergency orders, right? You can remember we had maximum capacity cases where religious institutions were saying, we're being singled out for closure or for audience limits, and how come bike shops get to stay open and we're closed. And people will recall those were very contentious and important. I don't want to suggest they were unimportant cases that the court was ruling on with kind of back of the napkin, 4 lines, here's what we've decided. And then relying on those shadow docket orders as though they had represented doctrinal change. And that is, in some sense, we're in a moment, and I know we'll talk about this a little bit more, but we're in a moment where notions of religious liberty are more capacious than they've ever been. Folks are granted exemptions in case after case after case based on religious claims. And that happens not in an order that we can read and understand and put in a case book, but in a couple of scribbled lines saying you're discriminating against religion. That's the one part. The other part, and this is equally important, is that we now have come to a moment where all of Establishment Clause doctrine, right? That's the notion that the government, cannot establish religion, has almost completely flipped. And that what we understood to be, we can talk about the Lemon Test and the framework, but what we understood to be the law, this quote unquote neutrality model that has been the law for most of our lifetimes, is now completely flipped. And we have moved into a model where we are seeing case after case after case, where the claim is made that the government's neutrality towards religion is actually bias against religion. And that's the moment we find ourselves in now. So we've seen an almost complete inversion of the two religion clauses of the First Amendment and how they are interpreted. And you're so right to point out that that has not happened in the light of day. That's happened in a series of sort of incremental but powerful steps. And it's also happened, as I said, some of it in the shadows. And we are truly at an extraordinary moment, I'll end here, where one of the most important cases last term, 303 Creative, and that was the case of a Colorado web designer who wanted to withhold web design services from same-sex couples. That was a religion case that came to the court and was argued and briefed and decided as a First Amendment speech case. So I'm just giving you examples of the sort of iterations of how it is that religion law is fundamentally unrecognizable in the last decade and a half, and also the ways that it's happening not in plain sight. And so it's hard to call it out. It's hard to describe what's happening because it's happening on the sidelines.
I couldn't agree more with that characterization and the audacity in a way that Justice Kagan pointed to during COVID of the justices. They disagreed on the facts. That's another phenomenon that I think has become more apparent and worrisome. They have to put pictures in their opinions to say that's what the coach was doing in the Coach Kennedy case. But in those shadow docket cases, Justice Kagan was, and I think Chief Justice Roberts was too, very concerned about substituting judgment for people who on the fly are trying to make really, tough policy, public health decisions. So that happened, but even the ones in plain view, I think of Fulton. And as you say, in another way, 303 Creative, the Establishment Clause and the ones decided last term, the Establishment Clause, I think, has been reduced to a cipher in a lot of ways. And freedom, free exercise is much more powerful than it ever has. You almost don't have to overturn Smith as some would prefer. And yet the narrative is this terrible time for religious freedom. And so that's also, I think, problematic in getting the American people to understand what's actually happening. It could be great for minority religions, these developments, and we'll have to wait and see. But I think that, this is important. You mentioned 303 Creative. The fact that it's a free speech case is huge to me because it can't be cabined. It's everybody gets to invoke the exemptions if they can make this compelled speech argument, and I think that was lost. But once again, the majority opinion says they're there. You're exaggerating. The dissent's hysterical. This is never going to happen, and yet the logic of the case is just inconsistent with the majority's claim that it's a small case. And Fulton, they said it was a small case. There's so much more. I would just, I want to turn it over to Eunice, but what should we be strapping our belt on for this term in your mind? What are the above the fold cases while recognizing a lot of the action's going to happen away from the headlines?
One other thing I want to say just before I get to your question, because you mentioned that there's now disputing of facts, and that's so important. And what Tony's referencing here is, Justice Sotomayor, who had to append to her dissent in the praying football coach case a photograph, because Justice Gorsuch's majority opinion said this is an intimate, quiet, private moment of prayer on the football field. And she had to show photographs of, the coach on taking a knee, surrounded by players, lifting up a helmet, photographs and news cameras running in order to say that's not true. But this is really important. And I think it's worth parsing for one quick minute. The other thing that we're seeing, both in that case, which was misleading as to facts, and for folks who've been following the case, Coach Kennedy, who was reinstated to his football coaching position and went back to coached one game 2 weeks ago and then quit. So he had moved to Florida. He didn't want his job back. He'd been living in Florida while the case was pending, and the court didn't take that into account. But I just want to flag for people that 303 Creative, this case of the web designer designing services, there was nobody on the other side. Her claim when she came to the court was, I am afraid that Colorado is going to sanction me for denying services that I have never provided. She had never created a wedding website. She had never refused a same-sex couple because she'd never even created a site. And so the entire case was a mountain of hypotheticals. And for folks who care about standing, that there has to be an actual case in controversy and a redressable harm. We had no case, no controversy, no harm, but for purposes of just people listening to how these cases play out, there was no one on the other side. There was no sympathetic same-sex couple the way we had in the Cake Baker case, also from Colorado, where you had a couple who was refused services with their mom, by the way, turned away, and you could tell two stories. Here there was one story. And so it's not just that the court is now sort of dismissive of facts and willing to set aside, hundreds of pages of court findings, for instance, in the affirmative action case. That's putting facts aside. This is deciding a case where there are no facts because nothing has happened yet. And I cannot describe to you how pernicious that trend is, because one of the things that we promise, right, our law students, is that there has to be an actual case or controversy for the court to get involved. So just very quickly, in part responding to just the maelstrom of controversy of the Dobbs leak, of the ethics stuff, we now have almost no cases docketed for this next term. The number of cases that are calendared is so staggeringly low. So it's hard to make meaningful predictions. The one I think everybody's probably watching is Rahimi, which is a case where somebody who had been adjudicated to be a domestic abuser, who lost his ability to bear arms, is now challenging that under, the Second Amendment, the very, very broad construction of the Second Amendment after Heller and after Bruin. And he may well win, in part because the logic of Bruin is, if we didn't have laws that restricted spousal abusers from having guns because there was no such thing as spousal abuse, right? We're seeing other cases in which, the law that prohibits you from going into a battered women's shelter being set aside because there were no such thing as battered women's shelters. So if you take the promise of Bruin, which is it has to have an analog at the time of the framing, then this is the exact kind of case that one worries about, that we are going to now set aside laws that prohibit you, if you have abused your partner, from having a gun. So that's, I think, the one that everyone's watching. The two that I think are barreling toward us very, very quickly are the Mifepristone case that was the Fifth Circuit decision to remove FDA approval of one of the two drugs used to terminate pregnancies. And that's a hugely consequential, potentially nationwide case that would make medication abortion much, much more difficult. And the other one is, we're just watching this Alabama case. We had, in Allen versus Milligan, an incredibly, incredibly significant win for Section 2 of the Voting Rights Act. The court was unequivocal that Alabama had to go back and draw a second minority majority district to better represent the population. And the state of Alabama has simply refused, just straight up saying we are only drawing one minority district and make me. And that case is already going back to the Supreme Court, because we are seeing, and this is really a chilling trend, state legislatures saying we're simply going to nullify the will of the Supreme Court in ways that we have not seen since massive resistance.
Yeah, it's after Brown. I mean, it's shocking. Just in terms of the First Amendment standing, even if we agree, it's chilling, and she made the case for that, I think there's a good argument that the court didn't need to take it. That even if there was standing, that there was so little evidence. If you want to make a case that you go to strict scrutiny and ask what the harms are and whether or not Colorado had a legitimate basis for doing what it did, the silence was deafening. And there was nobody sitting there to concretize that. I think that is worrisome, even if you buy the First Amendment generosity on standing grounds. And the other 2 points you're making, they're not, were the authority, consequences be damned. I think is highly problematic. And we won't have time, but I'd love to see you engage Alito if he were here with us on that point. I think it'd be a great conversation. And then finally, on their use of history and tradition, I wonder what you learned at Stanford that made you qualified to be a historian, maybe Lawrence Friedman. But I think history's become dangerously relevant, and we're supremely unqualified. The last person, when Lepore was here, who is an historian, she said she'd give the court a C. But she also said if she tells her law and history students whom she teaches together, the historians, you can open this room and you can find whatever you want in it. A historian would say, I'll find some artifact that would shed new light on that era, et cetera, working from a garment. She said all the law students said, I would love to find something that supports the result in the case that I want to argue tomorrow. And I think that's a real indictment of putting history in our hands. So much more, on and on. You have to come back for 7 hours. But I want to shift now to my colleague Eunice Lee to engage you about your book and the ethics and other themes. Thank you, Dahlia, and I will silence myself here.
Thank you, Tony.
All right. Thank you, Tony. I think I got the easier part of the conversation because I get to talk about this amazing book, which is, for those of you who haven't read it, it's a wonderful read with brilliant analysis of brilliant women. So the first question I wanted to ask you was just more to explain to us your impetus for writing this book, why the decision to write about women lawyers in the time of the Trump administration, and why these women lawyers in particular.
So the answer is really kind of sneaky, which is I started covering the US Supreme Court at a really interesting moment for gender and justice, because for the first time in history, there were 2 women on the Supreme Court. So we had Sandra Day O'Connor and we had Ruth Bader Ginsburg. And for many, many years, it was just the 2 of them. And it led to, I mean, I'm sure you've read some of the scholarship. Some of it was just such funny scholarship that tried to say there is this essentialist way that women do justice and women approach the law and this, and there were all these attempts, even before Justice Ginsburg came on the court, to say, oh, this maps onto all of the history we have from Carol Gilligan, the famous studies that suggested that boys like rules and women like standards and boys like crisp, sharp lines and girls like feelings, right? There was a whole, I read all those books when I was in college, that there was this notion that there was this female way to do justice. And it was really interesting to me because I noted, and I wrote about this a lot when I came on the beat, that, and the data later supported it, that, while Sandra Day O'Connor was a Republican appointee and Ruth Bader Ginsburg was a Democrat, and Sandra Day O'Connor was a sort of rugged cowgirl, and Justice Ginsburg was much more sort of dainty and feminist, regardless of the differences between them, and as I say, the data supports this, they disagreed about 50% of the time in their careers on the bench on cases in which gender, sexual harassment, discrimination inflected on the case. Their rate of agreement was 90%. So that's an amazing thing. And it really does suggest that there is not that there's a women's way of doing law, but there's a woman's way of thinking about the law as applied to gender. So I've been obsessed with that notion. And, we've now got a much larger, no longer an N of 2. We have a lot more women on the court. But I just love the idea that women had this kind of special relationship with the law. And then the Trump era happened. And I noticed almost immediately, Eunice, that the very first thing that happens is Sally Yates saying no to the travel ban. 4 of the 5 judges who enjoined the travel ban in the first 48 hours, women. That there seemed to be some way in which women lawyers were stepping into the breach that was fascinating to me and unique and singular. And I covered most of the women that I describe in the book. I covered those cases as they were happening. So I covered the travel ban and I covered the attempt to keep migrant teens at the border from accessing abortion. And I was just really struck by this through line of what is it about women and their relationship to the law that is interesting and unique. And so the book eventually became somewhat the arc of very different types of women lawyers and very different postures and very different cases, how it is that they saw themselves in this long 200-year slipstream of American law, and how they used their notions of law and democracy to change the world. So I think it was born of this question I've always had, and probably most women lawyers have, which is, I live this slightly split screen life, right? I, went to law school. I can blue book with the best of them. I know a lot of stuff. I have a JD. I'm smart, but I have experienced the world differently because of my gender, in much the same way that O'Connor and Ginsburg had. So what does that lead me to be and think and do? And I wanted to just probe that a little bit, because I think there have been so many books, amazing books, my friend Rebecca Traister, amazing books about women and democracy, but women in law felt like it hadn't been fully interrogated. And I was really interested in that story.
Thank you. And there's such a varying range of different stories in the book. And that's one of the things I really enjoyed about reading the different chapters, is that there's no one way to do law as reflected by the women's different approaches. So one thread that kept jumping out at me as I was reading through was the relationship between law and power. Law is used in many ways, or described in many ways, relative to power in the different chapters of the book. And the women lawyers have very differing orientations toward law vis-a-vis power. So what did writing this book change about how you think about law in relation to power, or what did it crystallize for you?
Such a good question. I mean, I think there were two big themes, and both of them surprised me as I was working. One was that I thought I was writing a book about lawsuits, right? I also am such a creature of the sort of law and order, dun, 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 that you just think if you just string along a bunch of really interesting lawsuits, you'd have a hell of a book. And that was what I thought I was writing. And I think what you're describing is the evolution that I came to about halfway through the book, when I was profiling Vanita Gupta, who starts as a lawyer, right? Who's doing all of this really vitally important litigation, and then suddenly finds herself at the Justice Department. And she's doing policy, and she's doing democracy. And then she finds herself, she blinks in the Trump era and finds herself at the helm of the Leadership Conference for Civil Rights. And now she's doing organizing. And what I realized, and this really happens about halfway through the book, you can win all the lawsuits in the world and still lose democracy, right? You're going to have to do organizing, you're going to have to do voting rights, you're going to have to do a whole bunch of stuff that is not strictly speaking lawsuits. It is not strictly speaking law, but it is very much about bending the arc of the law towards justice and democracy. So the book very deliberately ends on voting rights, which in a way we're looking at now, right? We're looking at a climate of vote suppression and election subversion and election denial. It's very clear you can win all the lawsuits and still lose if we can't vote meaningfully. And so I really landed at a very different place, where I went from super famous women lawyers like Sally Yates and Becca Heller and Ravi Kaplan to just organizers, nameless, not necessarily identified or identifiable, nobody whose face is on a mug. But these are the people who are changing the world. And these are the people, by the way, who got abortion on the ballot in Michigan, right? Who got abortion on the ballot in Ohio. These are the women who are changing the world. And so that second strand was the other one that I really wanted to play with. And the book starts with Polly Murray, who's the most famous legal influencer that nobody's ever heard of. And I became super obsessed with Polly Murray because Polly Murray, by sheer dint of historical accident, wasn't Ruth Bader Ginsburg. Polly Murray was, African-American and white. Polly Murray was gender nonconforming. Polly Murray did every single thing that other feminists got credit for 10 years before they did. Polly Murray also, by the way, wrote what would become the Brown v. Board of Education brief. As a law school paper, it was dusted off and used without her name on it, because Polly Murray was so far ahead of where the rest of the country was. And so one of these questions that I've been really obsessed with is what happens when you become as a culture so enamored of RBG and so enamored of some of the people in the book, right? Stacey Abrams, so enamored of Bob Mueller's going to save us all. Right now we're in the Jack Smith is going to save us all. And how it blinkers you to how change really happens, which is never a famous person saving us. It's us saving us. And particularly women and people of color know this, right? Because the people who get all the credit are never the ones who do all the work. And so I wanted to make this book into an argument for finding all the Pauli Murrays around us, because every one of our law students is a Pauli Murray, right? Every single one of us is a Pauli Murray. And just because our name is not on a tote bag doesn't mean we're not saving democracy. And so the book is ultimately, I'm sorry, this is such a long-winded answer. You can see I have not refined my elevator pitch in the year since publication, but I think that I wanted the book to be an argument for not waiting around for somebody else to come save democracy. And none of the women that I profiled in the book said, you know, I'm going to go to Target and somebody else is going to solve this. Because if they had, they would never have won these huge victories. And I want us all to think about the ways in which celebrity lawyer culture is getting in the way of massive, massive social justice and change.
I just have to say, I'm so glad this is being recorded, because I want to play that answer for my 1Ls at the beginning of every year, because it's so true. You know, change happens not through the big names that you hear of, but just on the ground, every person's contribution and things that you do in law school could one day become major Supreme Court victories. So you mentioned the ballot initiatives for abortion, and I wanted to pick up on that. I noticed that the book opens up with a description of the oral arguments in Women's Health v. Hellerstedt, which of course is a 2016 case upholding the woman's fundamental right to choose to end her pregnancy. And then the book closes with discussion of Dobbs v. Jackson, which of course extinguished that constitutional right in 2022, as we discussed a bit. So I wanted to know, from the vantage point of today, it's been not too long, but a little while, where do you see the movement for reproductive justice headed?
Yeah, I mean, I wanted the book to start with Whole Women's Health because I sat in the courtroom and I couldn't believe it. I called it, I think, the last great day for justice for women in America, because it was such a fun oral argument to cover. You know, Texas had a bunch of kind of pretextual regulations that had the open purpose of closing clinics. And it was just so fun to see, you know, suddenly there were 3 women on the bench. I think I joke in the book that when Griswold versus Connecticut was argued, that was the case challenging Connecticut's contraception ban for married couples. There were only men on the court, and they were so squeamish about discussing birth control that when you read the transcript, all of the justices are like, oh, I don't want to say any of those words. So they're all like, don't mention the devices. And it's just like, if you can't say it, don't regulate it, right? Like, you should be able to say the words. And so here we were suddenly, you know, in Whole Women's Health, where to have women on the bench bringing their experience of this is what it is to you know, be a woman moving through the world. It's a little bit of the split screen we talked about, you know, don't talk about this as an abstraction. These are our bodies. And it was such an amazing moment. And Justice Breyer, by the way, who just jumped right in and was such a champion of women's rights and women's autonomy and dignity. And then to just, in a very compressed amount of time, find yourself at Dobbs, and it's just over. And Dobbs, by the way, is an opinion, and this is slightly an answer to Tony's question about Justice Alito, where for the first and only time in history, an entire Supreme Court opinion was leaked and fact-checked in real time. Historians, physicians, economists all pointed out what was wrong with the draft and what could change. And Justice Alito didn't change it. And to me, that is a signature example of what power looks like, right? You have been fact-checked and found wanting, and he didn't change it. And so what I thought about Dobbs was, this is an amazing moment in which the actual lived lives of women, their economic, their social, their equality anxieties, all their health anxieties are invisible again to the court, as though it's Griswold again. And so I think the answer to your question is, Justice Alito has a line in Dobbs where he says, women are not without electoral power. If you don't like it, go fix it in your legislature. But it's such a paradox because this is the same Supreme Court that by way of Shelby County and by way of Rucho and by way of Citizens United have made it harder and harder for people to go and fix it at their ballot box. So you can't constrict the right to vote over the course of 15 years and then tell women, if you don't like it, vote, because that just strikes me as so utterly trolling that it's not even a fair comment. And so here's the good news, and I think it is good news if you care about reproductive health. I think the good news is that women took him very seriously. And women said, that's fine. If you want us to go and use our electoral power at our state and local legislatures, we will do that. And in all 7 of the states, including Ruby Red Kentucky, where abortion shows up as a ballot initiative or as a referendum, abortion wins by huge margins. That should be the end of the story, right? The fight moves to the states and voters effectuate their will. That's what Justice Alito called for. The 2 things that have happened, perhaps unsurprisingly, 1, conversations about a national ban, right? A national 15-week ban. So the promise that this was going to be a states' rights, states' prerogative issue falls away. And now we're seeing immediately several states, including Texas, that are going to make it impossible to cross state lines, which was the promise. Justice Kavanaugh in his concurrence said, nothing here is going to preclude people from going from one state to another. We're already seeing in 4 different states efforts to stymie traveling across state lines. So I think that that's one thing that's happening, that the promise that we do this state by state has been somewhat of a false promise. The other thing, and this is really what I'm thinking about and worrying about, and I'm sorry if it's a Debbie Downer end to the question, is that in the states where direct democracy could solve for this, we are now seeing efforts to break direct democracy, right? So whether it is Ohio trying to change the threshold last month, so instead of 50%, you need 60% support to get it on the ballot. Ohio is changing the language that's on the ballot this November, changing it so that it doesn't reflect what the amendment would be. Michigan trying to get it knocked off the ballot, Wisconsin seeking to impeach a Supreme Court justice who ran on an openly protective of reproductive freedom platform. So what frightens me, and I think we're seeing echoes of this kind of lawlessness, and I talked about the Alabama legislature, but I think that we're in this very frightening moment where the cure for a lot of what is wrong is direct democracy. And we are seeing efforts to either suppress it or to actually stick a fork in it around the country. And what frightens me is that the lesson that I think women really learned after Dobbs, and this was why the 2022 midterms went the way they did and why those 7 states prevailed on reproductive freedom, I'm afraid that the lesson is, well, that's fine. We're just going to make it harder to vote. And that cannot possibly be in a democracy the way we solve this problem.
So I'm going to ask one final question, which is going to, picking up on a slightly less than optimistic tone or a darker tone. And that's about the recent scandals around Supreme Court and the ethical, if not violations, at least ethical lapses that you and your colleagues at Slate and journalists at Politico have been so dedicated to uncovering. So I wanted to ask about this reporting and where you see it going and whether you see it having made a dent already, and what you hope for the consequences of all this coming to public light, thanks to the hard work of yourself and your colleagues, what the effects you hope to see will be.
So this slightly maps on to what I was flicking at when Tony and I were talking about press coverage of the court and my profound and unhappy, I just said I've covered the court for 25 years, And my self-flagellating conclusion is we've done a dismal job on this piece of it as the Supreme Court press corps. And I want to be super clear. My colleagues that cover the Supreme Court are the smartest, best people in the world, but they tend to cover doctrine. They cover the Supreme Court as though the justices, I've said this before, as though the justices are dead and the law is alive. And so we come out of an oral argument and we say, oh my God, did you see what happened to the dormant commerce clause in there? Without noticing what the justices are doing in their lives. And I think we conscripted ourselves to be kind of junior con law professors. And what we do is we write the first draft of the con law books. But that's part of the beat. It's not the whole beat. And one of the things that we are learning now, particularly, I'm just even thinking of this week's revelations about, Leonard Leo from the Federalist Society, heaving money at Ginny Thomas while Citizens United was pending. I mean, we all knew about this. A lot of this had been reported. Much of what we're seeing now, we knew. And so then the question is, why did we not think that was part of our beat? And I think a little bit of the answer to that is because we're junior con law professors. Let somebody else track down, the yacht and get on board and interview the crew and find out who paid for the glacier martinis. That's not our job, and that's fine. But it turned out it was nobody's job. It turned out nobody was minding the store, and so we've had what I think are these very, very flagrant, not just, that the justices are taking fancy trips or that they're allowing people with business before the case to pay for their mom's rent or their, grandnephew's tuition. I mean, all of that is a part of it, but it's the failure to disclose it that's shocking. I mean, they live under an ethics regime where if you accept things, you disclose it. And the notion that we're saying, that was a whoopsie. I just misread the rules for 22 years. I mean, these are the same people who sentence death penalty defendants to death for missing a deadline, right? Sorry, you missed the deadline. You die. And they're allowed to make 20 years of like little filing errors or what they call omissions on their reports. That's just scandalous. And so I think that this ends us kind of where Tony and I ended, which is, we are making a huge mistake by covering the Supreme Court as though it's two stories. And one story is the cases, one story is Dobbs, and one story is Bruin and affirmative action and so on. And then there's this other story, which is there seems to be a fairly high level pay to play grift going on that's been going on for a very long time and nobody noticed, and it's super bad. And on that second story, I think those stories are intricately connected, right? If a justice accepts a trip, a $500,000 trip, and then somebody shows up before them as a party in a case, I mean, those are connected. And if the kinds of big business plaintiffs who have a vested interest in dismantling the EPA or dismantling the Clean Water Act or dismantling unions have business before the court and they're giving justices lavish gifts, how is it that that's not part of the doctrine story of what's happening to the EPA and the Clean Water Act and campaign finance rules? And so I want to suggest they have to be covered as though they are of a piece, because they are of a piece. And more urgently, that the court, and this is the part that really breaks my heart, every time people like me criticize the ethical lapses, we're told that what we are deliberately doing is delegitimizing the court. And that is the sort of highest form of shoot the messenger that I have ever encountered, right? These are decisions the justices are taking. They are choosing to not have an ethics code. They are choosing to not disclose. They are choosing to write op-eds in the Wall Street Journal or give interviews in which they say, nobody can regulate us. Congress can't touch us. Those are choices. Those are kind of, as my kids would say, epic self-owns on the part of the justices. And then to turn around and say anyone who criticizes that is deliberately destabilizing the rule of law in America is just the height of hypocrisy. Every one of these problems, the ethics problems, has a solution, and has, by the way, a low-hanging fruit, elegant solution, which is just adopt an ethics code. Maybe just don't take multi-million-dollar gifts. But the choice to not conform your behavior to what the public expects, and then to say anybody who criticizes us has a vested interest in delegitimizing the court, I find to be heartbreaking. Because, and here's where I'll tell the truth, I am almost completely confident that the US Supreme Court will decide the 2024 election. I don't know how it cannot come before them. I want a functioning court more than anyone else in the world, because, and Anita Hill says this in the book more eloquently than I can, if we don't have a functioning justice system, what we have in its place is chaos. And you know who does not succeed in a regime of violence and chaos? Women and minorities and vulnerable people. It is in our interest to have a functioning court. And the fact that the court will not take the tiny steps to correct for that, but instead punches back and blames journalists and critics and academics, to me is the most heartbreaking thing in the world, because as Anita Hill says, and I will say, there is no plan B for when confidence in the court is gone.
You anticipated a lot of the wonderful questions that we're receiving in the chat brilliantly. They were focusing, many of them, on democracy and what do we do, and as others were concerned about how the court might get involved in the election, including this emerging Section 3 of the 14th Amendment question. And I think, and then how do we keep our hopes up? And I think you've responded to that as well. And what do we do if we fear that the rule of law is losing its force? And I think channeling that quote from your book from Anita Hill is a great one. She also said the problem sometimes is we live under a different sky. And I think that's out of favor right now. We want to, that's particularist, divisive, partisan, and we camp out on one side or the other. I think it's empathy. I think it's recognizing experiences have something to say about the law, and I think you've done just a really terrific job tonight of sharing those views. We don't have time. One of the questions that I wish we could have gotten to is the affirmative action case. Small impact or huge? He gives this out for the personal statements, and therefore it's not really a big deal. We'll see, I think, would be your answer. But at this point, I think we need to say thank you to Ms. Lithwick. You're fantastic. And it's everything that we had hoped. And for the members of the society, and yes, this is for those of you who are not, y'all come. We are going to resume in a little bit in a separate link with Dahlia, like a little salon. Our members, their contributions create this opportunity for all of you. And we're grateful to them. Normally, if we were in the room, I'd make them stand up and we have a round of applause for these wonderful souls. But imagine them, they're all good looking, every one of them, and smart and thoughtful. And you'll see that in a little bit. But right now I'm going to say good night to the rest of you. As I say, be careful driving home. And thank you, Dahlia. Fantastic.
Thanks, everyone.